Hi, this is the Business Guy. So what's the best form of property ownership for you? Okay, so there's joint tenancy, tenancy in common, tenancy by the entireties, community property. There are LLCs for legal protection, and trusts for privacy and estate planning. As a matter of fact, how you hold title is way more important than the wording of certain documents. For example, if your living trust says that your kids get your house when you die, but you don't put your house into that trust, the trust doesn't matter. The courts get to decide who gets your home. So it's not just having a trust, but putting the property into the trust. Likewise, significant tax benefits can be gained or lost, depending on how you own your property. So let's take a look at the different ways to own property and how it affects you. And hang on until the end and see what our staff attorneys recommend for most people. Number one, sole ownership. Sole ownership occurs when one person has complete interest in the property. Ownership is passed by the typical transfer documents or the laws of the state in which the person dies. The complete interest in the property is included in their estate. There's an old saying that goes, "Blessed are the poor, for they shall pay no inheritance tax," or for that matter, if they inherit real estate. When you inherit real estate, the beneficiary receives a full step-up in basis. Let's say your kids inherit your house. It's as if they bought it for fair market value at the date of your death. So they can eliminate a capital gains tax if they sell the property immediately after your death. In other words, let's say you bought a house for $100,000 years ago, but today it's worth $1 million. You die. The kids receive it as if they bought it for $1 million. They sell it and can pocket up to $1 million tax-free. If they hold on to it for a while and it goes up in value, they only pay taxes on the portion of the profits above the million. That is, the value on the day they inherited it. And the big problem with sole ownership, somebody sues you and you're like shooting geese in a pond. The property's in your own name for all the world to see, including the people who want to sue you and take it away from you. But you get the same tax benefits we talked about when you hold title in a land trust, a living trust, or LLC as well, and you can also get extra privacy and estate planning benefits. So hang on, we'll talk about those in a bit. By the way, if you're getting value out of this video, please help me out by clicking the like button below so YouTube promotes it. Thanks so much. And you can also click the subscribe button below so that when more videos come out like this one, you'll be up to date right away. Ownership type number 2, joint tenancy. Joint tenancy exists when two or more persons share equal, undivided interest in the property. Joint tenancy is not limited to spouses. Anybody can share joint interest. But there are tax benefits when this arrangement is shared only between husband and wife, called qualified joint tenancy. A joint property interest cannot be passed through traditional documents such as a trust or a will. Ownership of a joint interest passes by operation of law to the surviving joint owner or owners. In addition, property held in joint tenancy will not be subject to probate, so it does not have to go through the courts to transfer to the survivor of the former joint tenancy. Okay, so what's qualified joint tenancy? In qualified joint tenancy, half of the property is included in the estate of the first one to die. Because of this, the surviving spouse obtains a stepped-up basis only on the first to die's half of the property. If any non-spouses participate in joint ownership, the entire value of the property is included in the estate of the first one to die, reduced to the extent that the estate can prove that the surviving tenant contributed to the cost of the property. In other words, the survivor that received that half of the property doesn't have to pay taxes on the portion of the money that he or she put into the property. The next form of ownership we'll talk about is tenancy by the entirety. This is another form of joint ownership, and it's similar to joint tenancy, but it can only be created between husband and wife. Unlike joint tenancy, an interest cannot be transferred without the consent of the spouse. Tenancy by the entirety is only recognized in 24 states plus the District of Columbia for real estate, and only 17 recognize tenancy by the entirety for personal property, that is, non-real estate property. Tenancy in common. Now, tenancy in common provides an undivided interest in property between two or more people. Now, here's the difference in tenancy in common from other forms of joint ownership. Number one, interest can be owned in different percentages. Number two, A tenant in common can utilize a traditional transfer document, such as a trust or a will, but interest cannot be passed by operation of law. In other words, the surviving owner does not automatically get the portion of ownership that was held by the person who died. So when a tenant in common dies, their share of the property passes to their estate. They have the right to leave it to any beneficiary they choose. Now, the law makes me add here, nothing in this video is legal or tax advice. Get an attorney or a CPA for that. Now, that brings us to community property. Under community property statutes, all property earned or acquired by either spouse while they are married is owned in equal shares by each spouse. The essential principle of community property is that the earnings of either husband or wife and the revenue from their community property belong not to the one who produced the income, but to the community of the husband and wife. For estate conservation purposes, there are no restrictions on how each spouse can give away his or her half of the community property. There is no law requiring one person to leave his or her half to the surviving spouse, although of course many do. Currently, 9 states have community property laws: Arizona, California, Idaho, Louisiana, New Mexico, Nevada, Texas, Washington, and Wisconsin. And Alaska adopted the community property system in 1998, but it's optional. The amount that is included in the estate of the one who died is based on his or her 50% of the community property ownership. The beneficiary of the property interest receives a stepped-up basis on that portion of the property. The surviving spouse also receives a stepped-up basis on his or her 50% community property interest. Now, it's important to remember that the beneficiary can be chosen by the person before they die. Now, that is in contrast to joint tenancy, under which the surviving joint tenant automatically inherits the interest of the one who died. Now, here's the big risk in community property states. When one spouse is sued, the other spouse's assets are at risk. So if the judgment occurred while they're married, a judgment against one spouse can result in the seizure of the other spouse's assets and the garnishment of his or her wages. Imagine that. Your spouse does something in California that creates liability, and the courts can garnish your wages and vice versa. Okay, now that brings us to LLC ownership. By setting up a limited liability company, setting up an LLC for each one of your pieces of real estate, it's not just any LLC, but one that's been set up properly, such as those set up by our team of licensed attorneys and consultants who you can call and speak with. That way, each property is separate, so one lawsuit doesn't take all of your properties. So with an LLC, you have lawsuit protection when somebody hurts themselves on the property and sues you for more than your insurance coverage. And most importantly, you have the powerful charging order protection that the LLCs can offer so that when somebody sues you, you don't lose all of your property. Now, for tax purposes, most CPAs recommend against owning your personal residence in an LLC. See our videos on LLCs to protect real estate. Most CPAs recommend a living trust or land trust instead, so you don't have to pay taxes on a big portion of profits when you sell your home. That brings us to land trust. What's a land trust? A land trust is a document we create that allows you to hold property privately so your name does not appear on the title in the public records. So let's say that you get into a car wreck. You have $1 million of insurance, but you hit a stockbroker and you get sued for $3 million. If you own your house and investment properties in your own name, the lawyer suing you will easily find your house and any other properties in the public records. If you own your home, it shows some financial stability, and the lawyer will be much more likely to file the lawsuit. The opposing attorney can immediately have the sheriff pull up in front of your house, bang on your door while you're eating dinner, and hand you your lawsuit in front of all your neighbors. However, when you have your house in a land trust, your ownership is hidden. Your land trust does not have to be filed in the public records. It keeps your ownership private, and nobody has to know you own your house but you. Nobody knows the trouble I've seen. Nobody knows my sorrows. Plus, you keep all of the same tax benefits you had as if you held your property in your own name. Now, we like to hold title to each property in a land trust for privacy of ownership. and then have an LLC as the beneficiary of the land trust for your investment properties for legal protection. See our video on land trust for real estate for more info. That brings us to the living trust. A living trust avoids probate altogether. So when you die, the property goes to your heirs without having to go through the courts. So holding property in a living trust is a great estate planning tool. Okay, so what's the conclusion? What's best? Don't just leave me hanging, you say. Each person's situation is different, and you can call and speak with one of our attorneys or consultants to discuss your particular situation. But as a general rule, we put each piece of residential real estate into a land trust for privacy of ownership. And as we said, we like to make an LLC the beneficiary of each land trust, unless it's your primary residence. And then in that case, we use a land trust alone to maximize the tax benefits you can get out of owning your home. We also employ equity stripping strategies to protect your equity, which is beyond the scope of this topic, but you can see that in another video. So to get more information about your situation, give us a call at 1-954-400-1050 or fill out a free consultation form at assetprotectionplanners.com. Please like, subscribe, and share this video. See you next time. This is The Business Guy.